Series of constitution. Now I am talking about fundamental rights and fundamental duties. This is part 1 of fundamental rights and fundamental duties. The constitution of England is unwritten, hence there is in England no code of fundamental rights as exists in the constitution of the United States or in other written constitution of the world. This does not mean, however, that in England there is no recognition of the fundamental of the individual without which democracy becomes, without which this does not mean, however, that in England there is no recognition of those basic rights of the individual without which democracy becomes meaningless. The object, in fact, is secured here in a different way. The foundation of the individual rights in England may be said to be negative in the sense that an individual has the right and freedom to take whatever action he likes so long as he does not violate any rule of the ordinary law of the land. Individual liberty is secured by judicial decisions determining the rights of individuals in particular cases brought before the courts. The judiciary is the guardian of individual rights in England as elsewhere, but there is a fundamental difference. While in England the courts have the fullest power to protect the individual against executive tyranny, the courts are powerless as against legislative aggression upon individual rights. In short, there is no fundamental rights binding upon the legislature in England. The English Parliament being theoretically omnipotent, there is no law which it cannot change. As has been already said, the individuals has rights, but they are found on the ordinary law of the land, which can be changed by parliament like other laws. So there is no right which may be said to be fundamental in the strict sense of the term. Another vital consequence of the supremacy of parliament is that the English court has no power of judicial review over legislation at all. It cannot declare any law as unconstitutional on the ground of contravention of any supposed fundamental or natural rights. The fundamental difference in approach to the question of individual rights between England and the United States is that while the English were anxious to protect individual rights from the abuses of executive power, the framers of the American Constitution were apprehensive of tyranny not only from the executive but also from the legislature. That is a body of men who for the time being form the majority in the legislature. So the American Bill of Rights contained in the first 10 amendments of the Constitution of the USA is equally binding upon the legislature as upon the executive. The result has been the establishment in the United States of the judicial supremacy as opposed to the parliamentary supremacy in England. The courts in the United States are competent to declare an act of Congress as unconstitutional on the ground of contravention of any provision of the Bill of Rights. Further, it is beyond the competence of the legislature to modify or adjust any of the fundamental rights in view of any emergency or danger to the state. That power has been assumed by the judiciary in the United States. In India, the Simon Commission and the Joint Parliamentary Committee, which were responsible for the Government of India Act 1935, had rejected the idea of enacting declarations of fundamental rights on the ground that abstract declarations are useless unless there exists the will and the means to make them effective. But nationalist opinion since the time of the Nehru report was definitely in favor of the Bill of Rights, because the experience gathered from the British regime was that a subservient legislature might serve as a handmaid to to the executive in committing inroads upon individual liberty, regardless of the British opinion. Therefore, the makers of our Constitution adopted fundamental rights to safeguard individual liberty and also for ensuring, together with the directive principles, social, economic, and political justice for every member of the community, that they have succeeded in this venture in the testimony of an ardent observer of the Indian Constitution. In India, it appears that fundamental rights have both created a new equality and have helped to preserve individual liberty. The number of the rights cases brought before high courts and the Supreme Court attest to the value of the rights, and the frequent use of prerogative writs testifies to their popular acceptance as well. The classic arguments against the inclusion of written rights in a constitution have not been borne out in India. In fact, the reverse may have been the case. So the Constitution of India has embodied a number of fundamental rights in Part 3 of the Constitution, which are subject to the exceptions to be mentioned thereafter, to act as limitations not only upon the powers of the executive but also upon the powers of legislature. Though the model has been taken from the Constitution of the United States, the Indian Constitution does not go so far, the rather affects the compromise between the doctrines of parliamentary sovereignty and judicial supremacy. On the other hand, the Parliament of India cannot be said to be sovereign in the English sense of legal omnipotence, for the very fact that the Parliament is created and limited by the written Constitution enables our Parliament to legislate only subject to the limitations and prohibitions imposed by the Constitution, such as the fundamental rights, the distribution of legislative powers, etc. In case any of these limitations are transgressed, the Supreme Court and the High Courts are competent to declare a law as unconstitutional and void. So far as the contravention of fundamental rights is concerned, this duty is specially enjoined upon the courts by the Constitution. Article 13, by way of abundant caution, Clause 2 of Article 13 says, the state shall not make any law which takes away or abuses the rights conferred by this part, and any law made the contravention of this clause shall, to the extent of the contravention, be void. To this extent, our Constitution follows the American model rather than English. This is all about today's fundamental rights and fundamental duties. Thanks, regards.